How about upon your passing? You have, an estate that's less an estate. I'm saying your money, your car, your house, your 401k, anything that is considered an asset, that's your estate. You pass away and you don't have an estate plan. What's going to happen? Well, the state has an estate plan for you, because the state there's got to be laws in place for where does this money go. So I want to tell you what happens to your assets if you die and you don't have an estate plan in place. So on your death, we have to do a factual inquiry as to what's your living situation. If you're married and you've been married for a long time and you live in the state of Washington, you probably know we're a community property jurisdiction. So if you are married and let's say you're, first time marriage, you've been married for 30, 40, 50 years, the state says the deceased person probably wanted their assets to go to their spouse. So that's what the laws of intestacy say, that if everything is community property, then everything will go to the surviving spouse. It doesn't go to the state. Don't be worried that, all your assets are going to go to the state. That doesn't happen. It'll go to your spouse. Let's say you're married and this isn't your first marriage, this is your second marriage. And maybe when you got into the second marriage, you had accumulated some property, your spouse had accumulated some property. That's called separate property. So this is where we get into a factual inquiry of what is the nature of the property, of the asset. It makes a difference, because anything that's considered community property all goes to the surviving spouse. But if it's separate property, the surviving spouse only gets 1/2 of it, and the person who died, their descendants split the other half. So there can definitely be litigation, factual inquiry. It can get quite messy when there's no will and there are people claiming that they're entitled to the property because it's separate property. So that's just one example of problems that can arise, because if the spouse who died simply had an estate plan in place, there wouldn't have to be this inquiry if they did a decent estate plan. Let's talk about a single person. What happens if there's a single person and they die and they didn't have a will, and where do their assets go? Well, they're single. So then the next question you ask is, do they have any kids? The answer is yes, then the kids get it. So let's say there's 3 children. Let's say, just easy math for me. The person had $300,000 in assets. They have 3 kids. Each kid is going to get $100,000. That's what the state thinks that the person would have wanted. Did they want that? I don't know. Maybe they wanted to disinherit a problematic child. That's not always the case, but it's not that uncommon. Or let's say it's not that situation. They wanted everybody to inherit the person. They never did the will. But maybe one of their children is a special needs child or something along those lines where they need asset protection. Well, if you don't have a will, you're not going to have asset protection anywhere, period, when it comes to the situation where the person wanted their special needs child to receive the assets and not get bumped off of needs-based government benefits. It's not going to happen. So what I'm saying is, if you don't have an estate plan, somebody I spoke to recently said you have a wing and a prayer estate plan, because you have the estate plan that the state puts into place for you. And that's not the ideal estate plan by any means. So no matter what your situation is, no matter what your age is, no matter what your asset level is, you need your own estate plan. You do not want to have the estate plan that the state has in place for you if you fail to do so.